I want to see the addendum.
Yeah.
You know, the list of people who are going to be arrested on January 21st. That's what I want to see.
Why? Because we're on it?
Well, at least I want to know my ranking.
Yeah. I have a feeling you're up a lot lot higher than I am.
Oh, yeah? You're sitting right here.
I know.
Sarah Longwell.
We'll do this
Longwell.
It's an easy name to spell. We'll do this.
Social
We'll do
Security
this from the from the gulag someday.
Yeah.
And I hope that we're just joking, is what I hope. Hello, everyone, and welcome to George Conway Explains It All to Sarah. I'm Sarah Longwell, publisher of The Bulwark, and because I'm not a lawyer, that's my good friend George Conway from the Society for the Rule of Law to explain the legal news to me and to you. But
What if I said I don't understand any of the legal news
well,
that comes down the pike anymore?
did you just stop being capable of, like, why? Why would that happen?
I don't know. I think I'm having cognitive issues after the debate.
Yeah, is that right?
Yeah.
Do you want to talk about politics at all?
Yeah, we can talk about politics. But, I mean, I had a bad week.
You had a bad week?
I had a bad week, right? There was the debate,
Yeah.
which didn't leave me happy. There was the Supreme Court decision in U.S. v. Trump, which
Yeah.
we discussed, and then my dog died.
Oh, yeah. I'm sorry about
It's
your
okay.
dog.
It's okay. I'm not. This is not a sympathy. Yes, it's a sympathy play, but no, it was like I'm just not excited about this stuff anymore.
Yeah.
Just depressing.
I don't know that means you've lost your capacity for legal
Okay.
analysis.
All right.
I'm just
I just wanted to get that off my
I'm just
chest.
gonna take.
I just want to get that off my chest. Okay, but you know.
Yeah, I am sorry about the dog. I'm also very sorry about the debate where you know I know you really wanted to see those messages delivered with intensity and vigor, and that did not happen.
That did not happen. No.
I guess I bet our listeners would be interested just to know off the top if you have any thoughts about, because today is Thursday.
Today is press conference day.
And Joe Biden's going to hold a press conference now at 6:30. We don't know why.
Why 6:30?
Why a press conference?
Why a press conference? Well, I think the people demand a press conference. The people
Yeah.
in the media demanding a press conference.
You think he's holding a press conference just to be like, I will stand here and do a press conference and show you that I can do this?
I think so. I think
You don't think he has something to say?
Oh, you mean something more important to say?
Yeah.
No, I think he's just doing. I mean, I could be wrong, but I think he's just doing it to show he can do a press conference. But
Okay,
I could
so
be wrong.
Are
Are you
there's
thinking? Are you suggesting otherwise?
No, I am not sure.
Okay.
Right
Right.
now, I would say, though, that where things stand today on Thursday with Nancy Pelosi very much leaving open the opportunity for a new conversation, a renewed conversation.
No, she just simply said the president needs to decide. Make
But
a
he has
decision.
decided, according to
Oh.
him.
Oh, so you're thinking she's suggesting he hasn't decided the way he should decide?
I think it's not hard to read that out of that. Yeah,
You think Nancy would do that?
I do.
Yeah.
Yeah.
I think you're right.
I think that there's a lot of people saying this is Biden's decision. Only he will make the choice. I do think that if Barack Obama and Nancy Pelosi,
It's like making a decision and people yelling at you, like it's your decision, but
yeah, does it feel to you like the dam is breaking a little bit?
it depends from day to day. I mean, I thought the dam was basically shut down.
On
Shut it
Tuesday.
tight on Tuesday, and then
Yeah.
Wednesday morning, Pelosi put a big crack in the dam again. So I don't know. I honestly don't know which way this is all going.
Yeah.
All I can say is, and I said this on Morning Joe today, is they gotta resolve this fast, because the fight has to be taken to Trump.
Yeah.
That's the way this election gets won for democracy, one for the Democrats, one for freedom, one for the Constitution. The only way you win is by going after Donald Trump, and somebody's got to do that. And Joe Biden obviously did not do that at the debate quickly enough or early enough. He started to do it a little bit in the middle, but you know it's got to be a lot tougher and harder than that, and clearer. So the sooner that they can get onto that path with Biden or Harris or whoever, the better.
I wanted to ask you, the one interesting thing to me about this political moment is how utterly quiet Donald Trump has been.
Yeah.
Are you surprised by his discipline?
Yes and no. I mean, he hasn't been completely quiet. But he's being managed very well by Susie Wiles
And Chris
and
Lasavita.
Chris Lasavita. And that's the most difficult thing, is managing a psychopath, and that's not easy to do. But
They're clearly very talented, but also lack a moral compass. So
well, basically, if you work for Donald Trump and you facilitate his lies, you lack a moral compass.
Yes.
At this point, there's just no question about that. And they're managing him as best he can, and he's still sending out midnight tweets. That rally the other day was completely unhinged, but it got not so much attention because everybody's still talking about Joe Biden kind of staring into the camera on debate night. That rally was insane.
yeah.
But it was so typical of Donald Trump. People just accept it as normal, and we need to go back and make sure people see all that stuff and hear all that stuff, and that's why the Democrats got to get this resolved.
Yeah, well, speaking of legal things, one of the language I have used for a long time around Donald Trump is somebody has to prosecute the case.
Prosecute the case, exactly right.
So a prosecutor could be good.
I think a prosecutor could be very good.
Maybe the vice
I
president's
think
a prosecutor.
a dynamic, young, energetic prosecutor who sticks to a few points, which a good prosecutor knows how to do.
Yeah.
And I also think that a someone like that, particularly if she were a woman and black, would really get under her opponent's skin in a way that would bring out the absolute worst in him. Mm-hmm. So that's one way to look at this situation, and the other way to look at the situation is, what if the guy doesn't want to go, and what if it doesn't work out so well? It's a risk either way, and it's like, so I can't, I wouldn't hazard a prediction as to which course of action is best.
Well, two thoughts. One is,
I know you have.
I think about this a lot. I've been listening to a lot of voters. I've been listening to a lot of swing voters.
Yeah.
I've been listening to a lot of black voters, and there is sort of a widespread feeling that Kamala also can't win, which is a problem.
Yeah.
However,
I don't quite understand that.
Well,
is it?
Let me just tell you on this that part of it is that voters don't know her very well. They say this all the time, like, well, I thought maybe she'd be good, but I don't see her. But she can reset in a way that Joe Biden has now, I think, lost his ability to reset.
She charismatic. And I remember when she first announced her candidacy out. I think it was in San Francisco, and she filled this huge square, and she's
tons of promise. Yeah,
she can be very charismatic and dynamic, and sometimes not so much. But when she gets fired up, she's really, really good. And this is for all the marbles, so we'll see.
Well, and one of the things that you hear as a knock on her, and this is including from black voters, but not only, is sort of this Kamala the cop thing. But you know what?
Yeah, that's good in a general election.
That's good in a general election. So you know where it's good?
Cop versus criminal.
Cop or prosecutor versus criminal. That frame feels right at this moment. So it is possible that we are at a historical apex where you could see a real comeback story for her, and this being a particular moment where all you have 3.5 months to prosecute a case, and that's it. You go on offense the whole way.
Yeah.
And look, I think that if
they
people
got so
are going
much,
to vote
they
for
got
Joe
so much
Biden
material to
in
work
this
with.
diminished state, they will vote for her, and I think that it could energize a lot of things. Anyway,
you're making the case.
I could make the case for lots of other Democrats, but I am. Look, I've listened to voters be down on her for years, so it's not as though I have a Pollyannish view. But just on this idea of risk everywhere you turn, I think that we are now in a position, and I think the reason that Nancy Pelosi reopened the door, I think the reason George Clooney wrote that op-ed, and I think the reason Barack Obama, according to reporting, didn't stop him, is that they are looking at not just polling, not just focus groups, but a big data picture that shows not only is Biden losing in these swing states, not only is he underperforming the Senate races in a number of these states by double digits in some cases, like in Wisconsin.
I saw that. 12 behind Baldwin. That's just
But it's also
horrible.
states like New Hampshire, states like Minnesota, states like Virginia suddenly look like they're on the map for Republicans. And I think, and it looks like it could be a bloodbath down ticket for these swing state folks in Congress, which is what I think has people so spooked and why they think they've got it. The upside risk of Harris is starting to look more attractive than what looks like a sure bet on losing with Biden. People don't like to hear that, but that's certainly what the data shows. It's certainly what my focus group show. I'm going to do a focus group pod later today around all the black voter groups that we've done. And the thing is that there's a real narrative about black voters sticking with Biden. And the thing is they're like, yeah, he's probably better. They're worried about Kamala being able to win more so than the white voters are. But more importantly, it's not like they're hardcore Biden. They're just sort of like, I don't know what else to do. But if you give them an alternative,
and if you could,
and
if she could mobilize the black vote to even 3/4 of the extent that Obama did, that would be a huge benefit to the Democratic ticket. I don't know the numbers there. You would probably know the numbers better, but that made a huge difference in 2008 and 2012.
Yeah. I just think there's a lot of, I think we've got to do something. I think the stakes are too high. And look, to bring it back to the legal news, the immunity case. So like last week, we did a debrief on the immunity decision from the Supreme Court.
Yes.
I want to just kind of talk about it a little bit more
Sure.
because I think when we think about stakes, we already knew the stakes were extraordinarily high, but this immunity decision made the stakes even higher.
They absolutely did. And if a president does something that can be characterized as an official act, and there are many very bad things that a president could cause to happen that would be at least arguably within the scope of his official conduct by directing federal agencies to investigate his political enemies. And even, the SEAL Team 6 scenario is kind of crazy, but it's not so crazy anymore. So,
but you mean like something like the weaponization of the Justice Department?
The weaponization of the Justice Department, weaponization of any agency. Essentially, there is no practical limit for the president, although there may be practical limits for the people who follow his orders because they could still be held potentially criminally liable. But it's a difficult situation now that you're bringing this man into office, and the only person who's protected under that decision would be Joe Biden. Okay, the rest of us aren't. And as last I heard, the Constitution is about the president. Article 2 is all about the president, but the Constitution is all about protecting the rest of us. And so I just don't. As I said last week, the decision just went farther than it had to do. It decided cases it didn't have to decide, and it did so in a vague manner that leaves all sorts of potential for mischief. And that said, it doesn't necessarily, I don't think it does very much at all, close off justice in the particular cases against Donald Trump.
Right.
So except for the messing around with the Justice Department piece of it.
Yeah.
Which they were clear on.
So I also want to talk about the fallout that we've seen from the opinion in the pending prosecutions against Trump, because right now they're going back, right? So immediately following the immunity decision, Trump's lawyers in the New York hush money case argued that evidence involving official acts was presented at trial, so they want the verdict to be set aside. And we'll talk about that in a second, but first let's talk timeline, because of the immunity considerations, Judge Merchan postponed the sentencing, which was supposed to happen today, July 11th, and move it to September 18th. So first, let's talk about the political implications of the delay, and then I want to talk about how it could affect potentially overturning the convictions in that case.
Well, obviously, it's a political wash, I think, for Donald Trump, because he could have been sentenced right before the Republican convention. Actually, it would have been today.
Yeah.
Was the day. And that could have helped Joe Biden, okay, by shifting the issue back to Donald Trump, and it certainly would be an embarrassment before the Republican National Convention. On the other hand, having something in September that's bad happen to your candidate is a bad thing. So I think at the end of the day, it's probably a political wash, and it may actually be a plus or a negative for Trump and a plus for the Democratic candidate to have this discussion about what his sentence should be on 34 counts, on 34 felony counts for which there was a guilty verdict, to have that discussion after the Democrats iron out who their candidate is going to be. So it's either wash or kind of helpful to the Democrats, I think. Now, in terms of what's going to happen, I do not see this verdict getting overturned. And for the simple reason is, even though some of the acts that were the subject of evidence occurred in the White House, most of them didn't, and the things that happened in the White House were not official acts.
Well, so like it would be like, I was trying to think like, okay, well, what would they try to argue as official acts? But it would be like the Hope Hicks testimony, right? So he's talking to her in the White House saying, well, this is privileged.
Right. But she was talking to him in the White House about things that happened during the campaign and about about his personal life. Okay, so I don't see that as like an official a discussion about how to exercise official authorities, to analogize it to what the Supreme Court said was off limits in the Trump versus United States, which was the conversations with the Justice Department, where at least there, arguably, he wanted to get the Justice Department to engage in some law enforcement activity, even though it was completely ridiculous and in bad faith. When he's talking to Hope Hicks about whether it was good or bad that they paid the money to Stormy Daniels before the election, before he became president, and it was his personal money, I don't see how that's an official act. And the other testimony that involved things that happened in the White House was simply the custodial, the method by which personal checks or checks of the Trump revocable trust were given to Donald Trump in the White House to sign and then sent back to New York. That's his, he's doing his checkbook there. That's not an official act, right? He's writing checks on his own from his own account. That is not an official act, and any more than any more than anything else. When somebody's dealing with their personal finances in the office, they just happen to be that's where they are when they have to talk to somebody at the bank or send out pay a bill. They often do it at their desk at work. But that doesn't make it the business of the workplace. So
how does it work though now? Okay, so that has to be adjudicated though. The idea whether it was an official.
Yeah,
act or not?
I think what's going to happen is the reason why the sentencing was delayed was Justice Merchan wants to allow time for Trump to brief that, and then I think he will deny the motion for a new trial. It would overturn the verdict, but it would allow for a new trial, I think. And then he can proceed to sentencing. I think that's what he intended there. I think he wants to make sure that he gives the Trump lawyers the best shot they can give at this argument. He's already done that in the past and rejected it, but that was before the Supreme Court's immunity decision. And, I think it makes sense now that there's an additional issue to be litigated that is certainly going to be an issue on appeal. It certainly makes sense for him to allow some briefing time for him to decide it and then to proceed with the sentencing if he doesn't vacate the conviction, which I don't think he will do.
Okay, so you think that timeline probably holds where in September...
Yeah, I do.
They sentence.
I do.
Okay. And do you still think he's going to get jail time?
Yes. I think I don't see how he cannot.
What happens then? Whenever it's like...
Well, nothing will happen immediately because the sentence won't be executed until after all appeals have run. Mm-hmm. Okay, Merchan's not going to throw him in jail immediately. He'll sentence him, and then they'll stay the sentence pending appeal. But he'll be, once the sentence is issued, then the judgment of conviction becomes final and can go on appeal. So that has to happen before the appeal. And I do think, the only thing that Trump has going for him in the sentencing analysis is that he is a first-time offender.
Yeah.
Okay, and but that's counteracted by the fact that he was convicted on 34 counts. That this was a very, very serious and important series of events that was the subject of this trial, and the fact that he was held in contempt 10 times by the court, shows absolutely no regret or remorse. And, those are factors that all point to a sentence, not necessarily, a huge, long sentence, but, these counts are all 4 years apiece, maybe a year, maybe, a year or a few months, I don't know. But I would find it difficult. I would find it difficult not to sentence somebody to jail for this.
Okay. Judge George. All right. Let's talk about Mar-a-Lago. We're going to move on to the classified documents case in Florida. So, following the immunity decision, Trump requested the stay of the proceedings to allow for consideration of the immunity question. And on Saturday, Judge Cannon granted a partial stay so that the parties can brief the immunity question, right? So, Cannon's doing it too. Trump's filing said, specifically, President Trump is immune from prosecution on counts 1 through 32 of the indictment because the charges turn on his alleged decision to designate records as personal under the Presidential Records Act and to cause the records to be moved from the White House to Mar-a-Lago. As alleged in the superseding indictment, President Trump made this decision while he was still in office. The alleged decision was an official act and as such is subject to presidential immunity. So, is there any legal merit to this, or is this just another delay tactic?
I think it's just another delay tactic. I don't see how his taking he took the documents to Mar-a-Lago after he was president. There's no evidence that he actually issued any kind of order or took any kind of official act.
He didn't declassify them with his mind?
Right.
You sure?
I'm positive. I'm positive. Now, if he might have an argument, might have an argument if he did issue a declassification order, but that still wouldn't get him past the fact that classification doesn't matter in these cases. The case what this case involves is charges under the espionage for taking documents that didn't belong to him, that contained national security material, not that they were classified, that they contained significant national security material, and then he refused to give them back when he was asked. Now, the taking wasn't authorized. This is government property, but he nonetheless insisted on taking it to Mar-a-Lago, where it wasn't under government control, and he was no longer president. Then he refused to give them back, and he was no longer president at that point. So those weren't official acts.
Sure.
And the various counts involve of obstruction, where he's basically telling the government, NARA, and telling the FBI and DOJ lies, either directly or through his lawyer, or moving the documents around to hide them from the FBI, and trying to figure out whether he can get the security cam erased. All of that obstructive conduct happened when he was not president, and they were not official acts. So I don't see any coherent basis for that case to be dismissed under the immunity decision of the Supreme Court.
And here's the thing, though. You laugh and say that it's like crazy that or it's just a delay tactic. But isn't Eileen Cannon the one deciding?
Yeah, well, she is the one deciding. I think any decision to in his favor on this issue would get reversed, and it might be sufficiently outrageous to the Court of Appeals that it might be the opportunity that Jack Smith might have to get rid of her.
They got to find
this to a new judge. Yeah, we'll see. But I mean, this case is not going to play out this year. It's going to play out over the next 2 years if Donald Trump doesn't become president.
Yeah.
Knock
on wood.
Yeah, knock on wood.
Okay. So, also on the fallout from the Supreme Court decision, and the one that has the most direct bearing, on the January 6th election interference prosecution in D.C. So last week, you said there could be a mini hearing. This really stuck with me. I repeated this to other people. The idea of there could be a mini hearing in which Judge Chutkan parses out what in the indictment is an official act and what isn't. Do you still think we're on track for that?
I don't know. I mean, it's not clear what she is going to do. I don't think she officially has jurisdiction of the case, has had that returned to her yet. So we just have to wait and see what she does. She could also do it on papers. She could also have the government submit papers that would consist of grand jury testimony and FBI affidavits to get a sense of what the evidence is. We just don't know what she's going to do at this point. But I think it's pretty clear that at this point there will not be a full-blown trial before the election.
Yeah.
Yeah.
I think that's clear too.
That's pretty clear. Even I will concede that.
Yeah. You were bullish on how many of these cases we were going to see at least in front of the court at some point.
I was. But it's predicting how long things take in court proceedings that's a treacherous activity.
Well, the gears of justice better grind fine, because they sure don't grind fast.
They don't grind fast. They should grind faster, and they do sometimes grind faster. I mean, look at Bob Menendez. I mean, his case was given to the jury, I think, the other day.
Yeah.
And he wasn't indicted all that long ago. I mean, I think it's been less than a year for that case to get to trial.
Yeah, well, he had the gold bars like in his pockets, right?
Yeah, but and so Donald Trump had the classified documents in his bathroom. I mean, these aren't hard cases.
Yeah, that's right. Okay, fair warning, guys. We are now going to pivot into a much wonkier subject. Now that we've walked around the cases, we've seen how the immunity is going to be applied. I want to talk about something else.
Mm-hmm.
This Chevron case got decided. And I gotta say, I thought, this isn't a thing I know anything about. And for whatever reason, maybe it was because everything else was going on, I just couldn't bring myself to really go figure it out. But since I've got you here, and since it sounds like this Chevron case is a very big deal, I'm going to have you walk me and the audience through it. Because the Supreme Court, in addition to the immunity decision, it happened also at the same time, so it sort of got lost in the immunity decision. And they're handing down their big opinions at the end of the term. And so one was Fisher versus United States, which was about the January 6th prosecutions. But then the other big one was the Loper Bright Enterprises versus Raimundo, which overturned a prior case called Chevron. So, I said, I don't know anything about the Chevron. Do they mean Chevron like the gas company?
Well, the case, the original, they're talking about a decision in 1984. I think it was written by Justice Stevens. I could be wrong, but it's called Chevron USA against National Resources Defense Council.
Uh-huh.
And it was one of the most important decisions in administrative law, which is the subject you take in law school that some people take. If they want to go to become lawyers in Washington, they absolutely better take it. And you basically learn about the power of agencies, of administrative agencies, and how their decisions can be reviewed in the federal courts. And that's basically the subject of what administrative law course is. And what Chevron held was actually, in a way, kind of simple, although it's very complicated in application. There are lots of rules governing statutory interpretation that come up from time to time. I once won a case on whether or not the federal securities laws apply to foreign transactions, and there's a presumption, a rule of interpretation called the presumption against extraterritoriality, which made the difference in the case. You mentioned the case in the United States against Fisher, which was the case involving the January 6th and the scope of an obstruction statute that was amended after the Enron situation. And the question was, well, how do you interpret a clause that one provision, section A of the statute is kind of narrow, and the section B is like a catch-all. It says, well, otherwise, blah, 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 blah. And the question is, well, do you try to limit B to the context of A so that A doesn't become completely unnecessary? And there's a Latin phrase for that I can't pronounce. But that there's a rule of statutory interpretation that prevents that kind of surplusage, as lawyers call it. And there are all sorts of rules about how to interpret words in context. And the bottom line is that statutory interpretation is about reading a text and trying to figure out what it means in context And with, applying these various rules, which sometimes are in conflict and can be applied by different ways and different judges. Like the Fisher case, you had Justice Barrett dissenting with Sotomayor and Kagan, and then Justice Jackson joining the conservatives. These rules are not, they're good rules, but it's like you can apply them different. People can perceive differently how to apply them. This case, Chevron, involves a very special rule of statutory interpretation that kind of appeared out of nowhere in 1984. And what the court held in 1984, and it turned out to be very, very significant, is that, well, if you have a statute that's ambiguous, in the way that you're analyzing a provision that could, it could mean A, it could mean B, and you can't decide whether it's A or B, then the agency that is charged with administering that statute, for example, the NRDC case, the Chevron v. NRDC case, I assume involved the Environmental Protection Agency, you allow the agency to make the choice, and you defer, even though you're a judge, you defer to the court. You defer to the agency. And that, that became a widely accepted rule, but it was also questioned from time to time, because one of the things that it is the duty of the courts to do, and the duty in the province of the courts, goes back to Marbury against Madison, is to say what the law is. It's for judges to interpret statutes, not legislators, not the president. But when it comes down to it, every other situation a judge reads a statute, it's the judge's view of words, which are not written necessarily by agencies, because these are statutes written by Congress. It's for the judges to have the last word. And so over time, there's been a lot of questioning as to whether, from a philosophical standpoint, it made sense. And also there's a question of, do we want agencies really to be deferred to in defining the scope of their own authority? Where's the check involved in that?
Well, actually, can I just ask?
Yes.
My understanding is Congress gave them that authority, right? That Congress was the one that gave the agencies this authority. And so,
but the authority is defined by statute, and the question is, do judges independently decide the meaning of statutes in these close cases, one where it's ambiguous and can go either way, or does the agency basically get to decide, and usually probably in its own favor? And what the Lower Bright Enterprises versus Raimondo decision does is it overturns that rule and basically says that if a statute's ambiguous, the courts have to interpret it the way they interpret any statute, regardless of whether it involves agency power. And I don't have a problem with that, but a lot of liberals do, because they view it as a part of some kind of an overall program by the Federalist Society and by these conservative justices to basically destroy the administrative state. I don't think they like the administrative state. The conservative lawyers, I understand that they don't, but I don't think this is going to deal a death blow to the administrative state, because for a couple of reasons. One is this decision only affects when there's some serious ambiguity in a statute. Okay, and secondly is Congress can amend the statute. And Congress should amend the statute. It's one of the things that happens. One of the things that I think is unfortunate that has happened in our system of separation of powers is that Congress has become so debilitated that it just punts everything all the time, and so it doesn't want to amend statutes. An example was the bump stock case. Where it clearly, to my mind, the Obama administration had it correct that the National Firearms Act provision against machine guns does not cover bump stocks. And that was the longstanding position of multiple administrations. And then Congress punted, didn't amend the statute. So the Trump administration stepped in and wrote a regulation that contradicted every understanding that had previously been had about the statute. And that's a problem, with regulatory matters as well, is that some new problem comes up and it's not addressed by the original, by the original environmental laws in 1971 or by some statute. And instead of going to Congress and saying we need to regulate this and getting an amendment to the statute or having a new statute passed, the tendency is for people to try to litigate this, and agencies to litigate this, thinking that, well, we're never going to get something through Congress. And that's not the way it should be. Congress should be more responsive, and that's why we have Congress.
So I agree with this from Congress should be more responsive. Congress should do its job. In fact, Congress is the one who over the last, I don't know, it's more than a decade, there's been a real abdication to the courts.
Yeah.
A dependency on the courts.
Yeah.
But isn't this, again, knowing so little about it, it does feel like the courts are saying, all right, we're taking away this power that the agencies used to have, and now we're giving it to the court. The courts are going to decide. It's just like the courts now are in a position to decide everything. And with 6 conservative justices, is the concern that actually with 6 conservative justices on the court, that when you take it away from the agencies, that now, the Trump administration and the judges that he put there are all going to be in charge of making
that's absolutely part of the
liberal.
That's why they're very upset. On the other hand, the fact of the matter is, the composition of the court is the composition of the court, and the court had not cited Chevron, I think, in a number of years. And the way around the application of Chevron is to simply say, I don't really think this is ambiguous. I think it means X. I think that's the better reading. I don't find it ambiguous. And I don't, when it comes to saying whether something's ambiguous, that's ambiguous. There's a lot of play involved as to whether or not Chevron gets to. Yeah, it can be hard. We're dealing with statutes that sometimes use capacious language, and the question is, do you interpret them as capaciously as possible, or you try to limit it to some particular context, which is actually the issue that was in the Fisher case, which didn't involve an agency. So I think that That's why I kind of think that it didn't make a difference that they formally overruled. A big difference that they formally overruled Chevron. I don't think they were taking it seriously anyway. I think that they were, they were interpreting statutes the way they interpret statutes when they find that they're unambiguous. And you may not like those interpretations, and you may find there may be judges of different administrations or different philosophies who might lean toward finding more capacious readings of agency authority under federal statutes. But that's got nothing to do with Chevron.
Okay.
Right. But again, and I disclaim, just to be clear. I mean, I've never practiced administrative law. Thank God. Okay. It is.
Sounds boring.
It's brutal. It's a brutal area of law because you're dealing with these huge administrative records and you're pulling. I mean, administrative law litigation is a bear.
Yeah.
And I think it helps the cause of. I think it helps people who are more interested in deregulation. I think on balance, given the composition of the court, but the idea that it's going to lead to the destruction of the administrative state is absurd. I think it would take a lot more to destroy the administrative state, which might possibly be in the pages of Project 2025.
I want to do a whole episode on Project 2025.
That means I have to read it.
You do. And I also have only read, Amanda Carpenter delivered, Protect Democracy summaries.
Yes.
But so I would also, it's 900 pages.
Yeah.
And
there's a lot
authors.
more, right, yeah.
But it does.
But I want to see the addendum.
Yeah.
The list of people who are going to be arrested on January 21st. That's what I want to see.
Why? Because we're on it?
Well, at least I want to know my ranking.
Yeah. I have a feeling you're up a lot higher than I am.
Oh, yeah? You're sitting right here.
I know.
Sarah Longwell.
Yes, we'll do this
Longwell.
It's an easy name to spell. We'll do this.
Social
we'll do
security
this from the gulag someday.
Yeah.
And I hope that we're just joking. Is what I hope. We will do a whole Project 2025 episode at some point. I promise you. George Conway, still something of a. I hear the conservative in there in you. The person still trying to break down the administrative state.
It's very funny because every June, I start tweeting out about Supreme Court decisions, and I get
Resistance Twitter
starts saying, "He's not our friend. He's still a shill for the Federalist Society," and it's like, I never told you I was your friend. I mean,
It is. We are here to save democracy, but potentially not the administrative state.
Right. Well, no, I think the administrative state has to stay. I mean, I don't think there's any alternative to, some administrative state.
Yeah. What I would like is for the government to be small enough that Donald Trump can't hijack it and use it all for his own devices. I keep wanting to tell people this is a good case for smaller government and decreased executive authority, because Donald Trump could be president again.
Yeah, absolutely.
Yeah.
Absolutely. I mean, I want a boring, simple government doesn't do a lot. Okay.
I want to do basic things. I want to take care of roads.
Yeah. Make sure the Russians don't show up on at even Mar-a-Lago.
Yeah. I would like the Russians not to be
I give them Mar-a-Lago actually.
Well, I'm sure they've already got it.
Yeah, they do.
Yeah. Okay.
All right.
George Conway, as always, thanks for explaining the legal news to me and to our listeners. Don't forget to hit subscribe, leave us a review on your podcast app, email us at askgeorge@thebulwark.com, and we will see you next week.
Well, George Conway, he's a man with a plan. Got to sit down with Sarah Longwell, take a stand, explain all the legal problems they're piling high. With Donald Trump, oh my, oh my, oh my. He said, Sarah, let me break it down for you. There's obstruction of justice, corruption to the legal tangles and troubles, they're growing fast. It's a storm that's gonna last and last. Oh, Conway, tell Longwell all about it. Those legal problems can't live without it. From the emoluments to the Russian ties. Oh, Sarah, listen close.